topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, South Florida. Welcome to another Ask the Experts. This is our 12th year, and I got to tell you, 12 years ago, I thought that our best two shows would be personal injury law and family law. And boy, was I wrong. It turned out that community association law has been our number one show. That's based on how many people call during the show, how many people go to our chat line, and how many people text us. I mean, there is no one even close. And a lot of that is because one of the senior partners, Robert K., is so good at explaining that it just makes the show. We are so glad. We are so blessed to have him. Welcome, Attorney Kay.
Hello, Steve. Hello, everybody.
We're ready for your great wisdom, as always, the first Thursday of each month. And we're so good. I mean, we really are happy to have you. And we've already got questions already on the boards are ready. If you'd like to call in and ask Robert a question about community association law, those for you people who live in a condo or an HOA, and you have an association, all those questions you've been thinking about getting answers to, that's what we do here the first Thursday of the month. And also, they have an office in Tampa and one in Orlando, and we also have shows for those cities as well. The number here again is 561-623-9429. We always start off the show, Robert telling us about his baby, his law firm, K. Bender Rembaum.
No, thank you, Steve. As you say, K. Bender Rembaum is a law firm that concentrates in the area of community association law, condominiums, HOAs, cooperatives primarily. We work out of our offices in Pompano Beach, Palm Beach Gardens, Orlando, and Tampa. We provide legal advice to community associations of all sizes and dealing with every aspect of what a community association will deal with on a day-to-day basis. It might be dealing with covenant violations, giving legal opinions as to rights and responsibilities of the board relative to owner issues, outside vendor contract negotiations with cities, municipalities, collection of unpaid assessments, construction defect issues. We have a board certified attorney in construction litigation. We have a large number of board certified attorneys in community association law. Percentage wise of our attorneys, it's almost 50%. So that's a pretty high number relative to the rest of the state. So that's
well, I got to tell you, people go ahead, Robert.
I say that basically who we are and what we do.
Well, I got to tell you, the phone lines are already busy. So let's go right to the phones. Let's go to Liz in Winter Garden.
Hi there. Thank you very
much. Liz.
I'm an owner of a condo, and we recently had our condo association turn over from the developer to the owners, and this was a couple months ago. During the turnover, the same Cam who was there for the developer came over to represent the owners when after the turnover. I've been asking for some financial documentation for a couple weeks now, and I asked again last night, and abruptly learned that the condo association manager has decided to resign her position. So I'm not sure if the two issues are related, my asking for the financial documentation and her resignation. But my question is, as she was representing the board, is she still obligated to turn over any financial documentation related to the condo association? And then my follow-on question is, if there was any potential wrongdoing, either willfully or inadvertently on her part, is either the developer or the existing board be found negligent?
Well, you're very early in your association's self-rule by the unit owners, and what you've described is not all that unusual under these circumstances. The association books and records are open to the inspection of any requesting unit owner. The request should be to have access to the records to inspect them, not for them to provide them to you. If they're available in an electronic format on a website, they can direct you to the website to find them there. But you should be able to schedule an appointment to go in and have physical access to and inspect and make copies of all of the official records of the association. If the manager had committed any wrongdoing in her functions as manager, the association has recourse to pursue her, either for whatever financial damages the association may have experienced, or possibly with a complaint with the Department of Business and Professional Regulation relative to her manager license. The developer has obligations to the association as outlined under the statute. There should be an attorney involved helping the board in the transition period to gather all of the information that should be provided. It should be available to you to determine whether the issues in the development stage were handled correctly. There should be an engineer brought on board to make sure that the physical plant of the condominium was built in accordance with the specifications and the appropriate construction standards, as well as an accountant to do a review of the finances to make sure that the developer had spent money in an appropriate fashion and wasn't using it on developer expenses instead of association expenses. So that's pretty much what you're looking at this point. And the board should be actively working with professionals toward those issues.
Okay, thank you very much.
Okay. Thank you. Let's go to our chat line. Let's go to Stephen. Our condo association had a meeting with a vendor. All 5 board members attended the online meeting. No attorney was present and personal matters were not discussed. Is this a violation of the Condo Act?
Well, Stephen, it is not unusual for members of the board to meet with vendors in closed sessions that aren't open to unit owners when they're fact-finding. No decisions are being made no official decisions are being made under these circumstances, and the board is dealing with its vendor and getting information that will be presented at a properly convened board meeting. The issue here that Stephen's concerned with is the statute provides for any meeting of the board that the board will conduct association business, has to have posted notice and be open to unit owners to attend and participate. The problem with the statutory language is there's no definition of what conducting association business means in this setting. And through the years, it's been developed that that is generally considered when the board takes formal action. Makes a motion, a second, discussion and voting, and taking formal action of the association. Fact-finding meetings, meeting with potential vendors who are looking to be engaged by the association, dealing with just fact-finding, as it were, it is not considered taking action or be considered conducting association business for the purpose of having a formal board member of this type. The items he's identified about the attorney present and personnel matters are what the statute allows for the board to have a closed meeting and take action where unit owners would not be entitled to attend. But from what's described, this would not fall into the category of a board meeting that's required to be open to the unit owners.
Okay, let's go to our chat board again. TBC board. We have never collected reserves. Are we able to waiver one last time for 2024?
The answer is yes. The way the statute currently reads is that, and it's got a little bit of a language issue, that reserves for budgets in 2025, actually, I'm trying to remember the specific language of the statute. Budgets adopted in after December 31, 2024, which is intended to mean budgets in 2025, can't be waiving the reserves. Unfortunately, most of the budgets for 2025 are going to be adopted prior to 2025, so the statutory language can be used to allow for another year potentially of waiving some of these reserve requirements before the change in the law kicks in. So whether the legislature corrects that problem in the upcoming session is still an open question.
Okay, let's, you have a lot of, I guess, presentations you'll be making your classes for the month of October. It looks like you're really full. Can we go over those? Yeah.
Sure. Well, let's see. First thing to come up on October the 10th. There's going to be an expo next Tuesday in Broward. There was one this past Tuesday in Orlando, so that's already passed. We talked about that last month. There's an expo in Broward. I believe it's the Signature Grand. On October the 10th, we're going to have two classes at the Broward Expo at 9:30 in the morning. There's one on guest restrictions, and then at 2:30 in the afternoon is a legal update, a legislative update, which will go into changes in the law that took place in 2022 and likely 2023. Then on October the 12th, Thursday, from 12 noon to 1 p.m., a Zoom session, the screening process, develop procedures and train your committee, hosted by Campbell Property Management. Instructor will be Andrew Black from this office. There's one CEU for CAMS. Then on October 17th in Miami, Florida, there will be another expo. And again, we'll be doing the same two classes at 9:30. Not the same, I'm sorry. Elections is at 9:30, and the legal updates at 2:30 in the afternoon. And then on October 19th, I got two that week, Palm Beach Expo will be happening. Elections at 9:30 in the morning, and legal update at 2:30 in the afternoon. So those three expos are coming up in the next 2 weeks. And then on Tuesday, October the 24th, we have two things going on. We have a live presentation of a condo board member certification at the Tamarack Community Center from 5 o'clock to 7 p.m. Andrew Black will be presenting. There's 2 CEUs for managers at that particular presentation. That'll be certification for condominium board members. And there will be another expo in Bradenton, at which we'll be doing a legal update at 2:30 p.m. And then on October 25th, there will be an expo in Tampa, and we'll be presenting the elections class at 9:30 in the morning and legal update at 2:30. Then on October the 26th, we have elections for Community Association on a Zoom session, 11:30 a.m. to 12:45, hosted by Associa. Emily Gannon will be presenting from the Pompano office with 1 CEU for Community Association managers. And October 31, there will be a class on Community Association collections. Should I pay or should I go? From 12 noon to 1:15. It's a Zoom presentation by Alan Schwartzide from our Orlando office. And then on November 1st, we have a 2024 legal update, 2 o'clock to 4 o'clock p.m. Zoom. Michael Bender presenting in association with Community Association Resource Group. And that's on November 1. So all of these items you can find on our website, kbrlegal.com. Go to the calendar and then identify which of the classes that you intend to participate in and register so you can get the Zoom information or register for the live ones. Information on the locations of the expos are also indicated on the website as well. So it's a pretty busy and packed month of October.
And most of them, these are all free, right?
All free.
Get yourself a teacher, because a lot of these do get filled up, and you want to make sure you got a seat there. And they're really good. I've been to several of them, and I was talking last week on our show. I think it's in Tampa. When I was there, there was a guy and his wife there. And you could tell he did not want to be there. And he at first was, I can't believe I'm here. I would say after 15 minutes, he was asking more questions than anybody there. I thought that was really funny. But it's really.
That does happen. A lot of good information comes.
Okay, so let's do this. Let's go, before we go to our first break, let's go to our text line. Kelly in Boca Raton. She is in a condo. Can you do a lien on a condo who isn't complying?
Well, Kelly, in a condominium, the only thing you can lien for is unpaid assessments, and anything that the declaration identifies as an assessment. So if you're talking about non-compliance, say somebody is leaving trash thrown around the common elements, or they have a fine against them for violating some covenant, the statute expressly does not allow for a lien to be imposed against the unit under those circumstances. Only for unpaid assessments that are due to the association with the appropriate notice in advance by the association, and then the procedures that the statute provides for the attorneys as well.
Okay, let's go to Linda in Lake Worth. She's on the phone right now. Hi, Linda.
Hi, how you doing?
Doing fine.
I have a question about conflict of interest. We have a board president for a master association. She also works for the same management company. She's an LCAM. So she's getting paid. And we thought that might be a conflict of interest.
Well, it is a potential conflict of interest and a real conflict of interest, but whether or not it's a legal problem would be relative to whether there's any disclosure provided of the relationship and then the appropriate abstention on issues that involve matters that would be pertinent to the management company or her personal financial opportunities. So the fact that she is employed by the management needs to be disclosed. And it sounds like it is because you know about it. And then it becomes a matter of if issues come up that fall within the purview of her employment, that she not participate in the vote because of that conflict.
Okay. All right.
Does that answer your question?
Yeah, we were a little concerned about, signing contracts and, just there's not a lot of full disclosure with that too, presenting it to the rest of the board. So we were concerned about that.
Does she hold her office as president because the board appointed her that, or how did she get to that? And would they want to keep that?
She was appointed the president before she actually started working for the company.
No, okay. So as long as the full board is aware of her involvement with the management company and they take the appropriate steps on issues that would affect the management company, which can be a lot of items, then she would need to step aside on those.
Okay.
So keep your eye open for that.
Yes, I will. Thank you. Thank you very much.
Thank you, Linda. We're going to go to our first break. If you'd like to ask a question for Attorney Robert K., 561-623-9429, 561-623-9491. And if they'd like to call the office for Tampa, Orlando, West Palm, or your Pompano office, what is that number, Robert?
800-974-0680. You can write to us at info@kbrlegal.com or go to the website, kbrlegal.com, and there's a contact box on the first page. Fill it out, and someone will get back to you.
Okay. We're going to go to our first break. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
We are back. This is the Ask the Expert show. We bring you the top experts in the field of legal, health, financial, and home improvement throughout South Florida. We're really glad you've tuned in today to listen to the show. This is the first Thursday of the month. We always do the K. Bender Rembaum show. It is our highest rated show. If you have a question, we have a chat line. If you're watching us on TV, if you have a question that you would like for us, you'd like to call and ask Robert. The number here, 561-623-9429. If you have a question, this is K. Bender Rimbaum, Community Association Law. Let's go to the chat line. This is a let's see. We asked for a special assessment for insurance increase. This is Stephen again. That's fine. You can write in your questions. Email with spreadsheet were used between board members to calculate the assessment. Are the attachments official records?
Stephen, the issue of communications between board members by email being official records or not is one that is not as black and white as we would like. Written records of the association are considered part of the official records that are open to inspection. The problem is whether emails of the board members fall within that category, and it's been the opinion of the professionals and in particular the division that personal email accounts of board members are not part of the association official records. And that can extend to management companies that have their own proprietary email addresses, even though they're involving association business. So whether or not it's absolutely legally part of the official records, there are differences of opinion as to that. If you're looking for perfect safety from legal challenge, you would include it in the official records and make it available to anyone who wants to see it. If you want to take a more liberal approach to the interpretation of the statutory requirement and hang your hat on the issue that private email accounts are private and whatever's in them are not part of the association official records, then that's a business decision for the board to make. And then ultimately, if a challenge is brought, it would be up to either a court or the Division of Condominiums Arbitration Section to reach a legal conclusion on that point. In my experience, though, so far, the information in emails that are owned by the individuals are not part of the official records.
Okay, let's go back to the phones. Let's go to a caller in Boca Raton. Good afternoon, caller.
Yes, good afternoon.
You have a question for Robert?
I do. We live in a fourplex condo. My neighbor next door claims he has a medical marijuana permit. Sometimes the smell is just overwhelming. Is there any way that can be addressed?
That is also a difficult situation when there is a medical permit for the use within the unit. The statute doesn't allow for use beyond the unit, so if the individual's using it out on the common elements, that's an easier issue to address. But sometimes smells permeate between units in condominiums, and there would be little legal recourse available to the individuals because what they're doing legally within their individual unit. So the board can get involved to put your concerns on notice to them, and perhaps they can adjust the way they treat themselves for their medical condition. But beyond that, it could raise issues of potential discrimination defenses by the individuals because of their medical entitlements.
Okay. All right. Thank you so much.
Thanks for calling.
Good luck.
We are getting a lot of thank yous, Robert, for the show. I think we've got a lot of new people today. Let's go back to the chat line. Robert and Delray, How do I find out if a management company is licensed in the state of Florida?
That information is available on the Department of Business Professional Regulation website. All licensees in the state of Florida, whatever category they are contained within the division's database. And so you go to the DBPR website and click on Community Association Manager, and then fill in the information of either the individual or the company, and that would give you the information as to the status of any license that may exist.
Okay, let's go to Robert in Tampa. We have a show in Tampa. They want to know, can you publish a deadbeat list at a board meeting?
Well, if it's at a board meeting, it's not going to be a published list, so that concern shouldn't really exist. The board certainly has the right and authority to review the status of all the accounts at a board meeting, and the identification of the individuals who are delinquent to the association would invariably come up and be known. That's not the same thing as publishing a deadbeat list. Publishing a deadbeat list is putting a list of people and putting it up on the bulletin board, or sending out an email, or doing some form of publication. And the general advice on that is not to do it. There's exposure to the association for a number of different things when they do that. There's a privacy concern. There's an issue. What if you made a mistake in your calculations and you publish someone who actually wasn't? So the potential downside of doing that far outweighs any benefit you get by shaming people to their neighbors. So that's not a method that is generally recommended.
You know, this really shows people that if you're on the board, how important it is to have legal representation. There is so much to know out there of things, what you can and cannot do. But really I want to take a step
it's always
further.
Changing. It's always changing.
Well, I want to take it a step further, because I'm sure there's a lot of people listening right now. They're board members or people who live in a condo or HOA association, and they'll call up the firm that represents the association, and it takes them forever to call back, and it gets very frustrating. Now, I know for a fact that how important customer service is to you. And when I come to the office in Pompano, there's always 2 or 3 ladies in there working, and you try to get back within 24 hours. And I think that is so important, Robert.
Well, our aim is that calls are returned the day they come in, and emails responded to promptly, if nothing else, to acknowledge we have them and are working on them. But we know that our clients aren't reaching out to us because they just want to check in. It's because they have an issue and they need information, and they need the response relatively quickly. And that's what we strive to give them, and to do it in a way that's readily understandable to lay people. You don't need somebody to translate what your lawyer writes to you, and that it's done in a cost-effective manner.
Let's go back to the phones. Let's go to Susan in Tampa. Well, you're popular in Tampa today.
Yeah, good for Tampa.
Hi, Susan.
Hi, thank you very much. I have 2 questions unrelated. First of all, how much discretion does the board have regarding an owner-approved material alteration to install a ramp in the lobby? For example, can the board also remove wallpaper, add lighting sconces, and so forth in on walls nearby, but unrelated to the ramp installation.
Well, if an owner is making a request for a reasonable accommodation for a disabled condition,
Yeah. No, that wasn't part of it.
That's not part of it. So this is just the board doing it on their own?
No, the owners approved the material alteration to install a ramp. That's been approved. But in addition, the board would like to do other material alterations to the lobby, such as removing wallpaper, adding lighting sconces, and so forth. That was not part of the approved material alteration for the ramp. Is that allowed?
Well,
to do additional alterations?
We're going to have to look to your documents on that to determine whether there's any benchmark provisions within them that allows for the board to make any decisions on that, or whether it's still going to require a vote of the unit owners. Generally speaking, what you've described would fall under the category of material alterations that may require a unit owner vote. So depending on how your documents are written on that, sometimes we see a dollar figure. I'm sorry, they're silent?
Yes, they're silent.
If they're silent, then the board does not really have much discretion on that, and we'll need to get a vote of the owners.
Thank you. My second question is, can a board member tell owners if he or she supported or opposed salary increases in the budget in general without mentioning any dollar amounts of the salary? Can they simply tell owners if they opposed or supported a salary increase?
The board members have the power to tell owners anything they choose to tell them. They have protection of privilege on certain information, but it's the board members' privilege to hold private or to disclose. So if a board member wants to disclose that information, there's no legal impediment from them doing so.
Thank you very much. Thank you.
All right, thanks for listening.
Let's go back to the chat board. Should electronic copies of executed contracts be available to board members? How about owners?
Well, board members are, I'm assuming, owners. They don't have any special rights to official records by virtue of being board members unless the board has adopted a policy that gives them that right. Otherwise, they have the same right as any other unit owner, and that is to have the official records made available to them upon written request to inspect and copy, or through the website of the association electronically. And so that would apply to both board members and unit owners on that particular question.
Okay. Let's say with the chat line from R. Willis, this is regarding material alteration. Can bushes be removed from the common area and not be replaced?
Well, this question is different for HOAs than it is for condominiums, marginally, because material alteration is really only a condominium issue generally, because the statute that creates the term is only in the Condominium Act. In homeowner associations, what the board can do relative to alterations to the common area is spelled out in the governing documents, and typically the board has full authority over them. In a condominium, landscaping has been viewed a little differently than most everything else. Something as simple as a color change on a building has been considered a material alteration by the Division of Condominium that could require a vote of the owners. So landscaping generally does not have that same standard as other parts of the common elements in the structures. So if the board decides some re-landscaping is done and some bushes are removed and not replaced, in my experience, it's generally not been something that has been viewed one that requires a vote of the unit owners. That much is a little bit too involved for unit owner vote. That's something that typically a board can do on its own.
Okay, let's go back to the phones. It's Liz. Hi, Liz.
Hi, I called earlier. Thanks for taking my call again.
Yes,
So
ma'am.
I had a different question that as I was going through the financial documents, that from the condo association, before the turnover occurred and before we reached 50% of the unit owners that had, I'll say, buildings in a property, there were about 3 years where the developer had annual budget and they were collecting condo dues from the unit owners that had bought into the condo. When we got to the 50% mark and owners were able to vote on the budget, it turned out that while the original budget documents were planning for, let's say, about $40,000 a year to be set aside for reserves, when we learned what was actually in the reserves account, it was more like $10,000. Is that something that if the developer is taking dues from the owners and they have, assigned a budget, can they lawfully transfer money from reserves to fund the operations account?
Not without a vote of the owners who, other than the developer. If the budget calls for reserves, then the reserves have to be there. And that's part of the work that an accountant would do in your post-turnover review, so that when you have all your claims for developer issues, that's going to be one of them.
Okay, so the developer can do it for make sure that anything that the owners paid into the reserves is set aside for the reserves, but not on the developer side?
No, the developer can't move reserves on his own. The developer doesn't get a vote on that, only the unit owners.
Okay, my question is more that, as part of the budget, the developer was saying, we're going to set aside $40,000 a year for this. And in reality, they had only set, so which would have been $120,000 altogether. But when it came time for the vote, there was only $10,000 in the account.
When you say it came time for a vote?
For the first vote where there were 50% of the owners that had bought into the building.
Right, but what are they voting on?
They were voting on the budget as well as the reserves.
Well, owners don't typically vote on the budget. They vote on whether or not to waive reserves. And if they're having you vote on the budget itself, that's not a proper vote. The board is supposed to adopt a budget on its own.
Yeah, so I'm sorry, I did misspeak. Yes, the vote was only for the reserves, whether to waive them or increase the funding for the reserves. But my question is more about what is the developer's responsibility to actually fund the reserves account that they had said that they were going to fund as part of those budget documents? Do they have an obligation to fund the reserves?
They do. And when you're voting on waiving reserves, you're voting for the next fiscal budget year, not what's been done in the past.
Okay, so if the developer never voted to waive funding the reserves, we should have expected them to be fully funded for that year.
Well, the developer is not allowed to waive reserves on its own. That would take a vote of the unit owners. And if you didn't present it to the unit owners, and the owners didn't vote in favor of a reduction, then it needed to be fully funded. So what you could have is an operating deficit and full reserves. There needs to be a resolution to that, and the developer likely is going to be the party that's going to be directed to. But you don't want to do it piecemeal. You want to put all of your issues together before you go after anything. And so you do need an attorney that's versed in that issue before you jump in with the developer.
Okay. No, thank you very much. I know that the audit is still going on after the turnover documentation. So I'll reach out to
you may find there's a lot more than just that.
I would expect so, given what you've just said. Thank you.
Okay.
Well, we've had just a board full of people on the chat line and the phone line today, as well as all of our text. We still have a few minutes left, Robert. Give everybody the information, how they can reach your firm.
Well, you can reach us at 800-974-0680, or you can write to us at info@kbrlegal.com, kbrlegal.com, or go to kbrlegal.com. There's a contact box on the main page, and just fill out the information there.
And I'm going to take the questions that we didn't get to ask you today, both text as well as people who wrote in, and we will add them to next time. Remember, this show is on the first Thursday of every month from 5 to 6. And we also have a Tampa show that's on the, I believe it's the last Thursday of the month. And we have an Orlando show that's on the last Tuesday of the month. So a lot of shows, but the most important thing is, if you'd like to go back, a lot of great information today. You can go back to your website, Robert. The shows are up there, and they can actually watch them or listen to them.
Click on the resources tab, and then you find all that information there.
Great. Hey, thanks again. We've been doing this for a long time together. You're my favorite. I'll see you next month, Robert.
All right. Enjoy October.
Yes, and we'll see you all next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Experts show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.